Order. Welcome to meeting number 56 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Standing Order 108 sub 2 and the motion adopted on January 30th, the committee is pursuing its study on Canada's bail system. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person and also using the Zoom application. Just a few remarks for the witnesses and members. Please wait until I recognize you by name before you speak. For those that are on Zoom, use the raise hand function to identify yourself if you wish to speak, and activate your mic and please mute yourself when you're not speaking. Interpretation, for those in the room, just make sure you put it on the choice that you want, English, floor, or French. And same with those via Zoom. Please select your desired channels. I use a couple cue cards just for those that don't know, that the members know. So when you're down to 30 seconds, I will raise the yellow 30-second cue card, so try to keep an eye for that. When you're out of time, I'll raise the red one, and I just ask you to wrap up within a few seconds of that. That being said, we have three witnesses in the first hour. We have Greg Delbigio from the Canadian Council of Criminal Lawyers, I think online, criminal defense lawyers, and we have Garen Arnett Zargarian, a member of the Board of Directors for the Criminal Defense Advocacy Society, here in person. And we have Melanie Webb from the Canadian Bar Association Criminal Justice Section via video conference, so welcome. You each have 5 minutes, and we'll begin with Mr. Delbigio for 5 minutes.
Thank you for the invitation to appear. The study of bail is hardly new. In 1965, Professor Martin Friedland studied the problem of pretrial incarceration and published his results in his book, Detention Before a Trial. The Charter of Rights came into force in April 1982, and in that document, bail was guaranteed through Section 11E, guaranteeing that any person charged with an offense has the right not to be denied reasonable bail without just cause. In 2012, the National Symposium of Reinventing Criminal Justice studied bail and published its reports and recommendations. Under the heading aimed at reducing the remand population and improving the bail process, the report states, the symposium participants emphasized the importance of early stage of a criminal proceeding and the need to allocate resources at the front end of the criminal justice process. Bail was once again studied in 2016 by the Steering Committee on Justice Efficiencies and Access to the Justice System. In that 2016 report, the committee wrote, accurate issue identification and effective reform depends on a foundation of reliable evidence. Our review of available data shows that there is a dearth of comprehensive, objective, and reliable information about the bail process that would permit strong inferences or accurate conclusions about its operation. The absence of reliable, objective, comprehensive data about various aspects of the diverse bail processes across this country has hampered the accurate identification of issues and conversations about reform. But the report did note and made a recommendation about the benefits of bail supervision as opposed to incarceration. Bail was considered by the Supreme Court of Canada in 2017 in the case of Regina versus Antic, a case which I'm sure all of you are familiar with. But in that decision, the court referred to Professor Kent Roach and his work, and where Kent Roach observed that although the Charter speaks directly to bail, the bottom line so far has been that the remand population and denial of bail have increased dramatically within the Charter. In Antic, the court also recognized that pretrial custody affects mental, social, and physical life of an accused and his family, and may also have a substantial impact on the result of the trial itself. Again, in 2020, the Supreme Court of Canada considered bail in the case of Regina versus Zora. And in Zora, the court observed that judicial officials making bail decisions are required to give particular attention to the circumstances of the accused persons who are Indigenous or who belong to a vulnerable population that is overrepresented in the criminal justice system and disadvantaged in obtaining release. In other words, the court recognized that there are people who are caught in the criminal justice system or find themselves in the system who are disadvantaged and overrepresented, and as a result of the disadvantage, they are disadvantaged in obtaining release. In Zora, the court observed that there is a culture of risk aversion that contributes to courts applying excessive conditions. I am not an elected official. I'm a lawyer. I can't comment on what might motivate elected officials to suggest that bail reform is needed, or that streets might be unsafe, or that more people should be denied bail and should be held in jail while presumed innocent. However, to be clear, I am in favor and do recommend that informed discussions about important issues, as opposed to attention-seeking quotes and headlines, is always good. I don't suggest that everyone charged with an offense should be granted bail. I do suggest that using jails to address what are often social problems arising from considerations such as homelessness, addiction, mental health challenges, and poverty is regressive. I do say that frontline prosecutors are already well equipped to oppose requests for bail in appropriate circumstances. Frontline judges are well able to grant or deny bail as is appropriate, and appeal courts are well equipped to review bail decisions. So if reform is considered, I urge that it be evidence-based, and statistics, not guesswork, and not impressions. How many people are currently in pretrial detention? For how long? Why are they detained? Is it the primary, secondary, or tertiary considerations? How many people who are released on conditions breach? And just if I can wrap up in 20 seconds, what offenses are they committing? And if people are released and offenses are committed, was it because of a system failure, or does it reveal a gap in the existing law? And I urge you that if there is a concern that people are being released and committing offenses and that is revealing a problem, I urge you to study transcripts of their bail hearings so that you can understand accurately what it is that took place and why the people are on the street. Thank you.
Thank you. And now we'll go to Mr. Arnett Zargarian for 5 minutes.
Thank you for the invitation to address this committee. I am a criminal defense lawyer in Vancouver, and I'm here on behalf of the Criminal Defense Advocacy Society, an organization of defense lawyers from throughout British Columbia. This committee has an opportunity to meaningfully improve Canada's bail system, uphold constitutional rights, and protect the long-term safety of our public. This should not be an either-or proposition, nor will it be a quick fix, but it is necessary. As the Honourable Minister Lametti has said, when making important decisions such as this, the devil will be in the details. This committee has already heard some of those details, and I will not repeat all the stats or all the data, but it is staggering. For the past 30 years, crime in our country has steadily declined, yet our pretrial jails have grown overcrowded with those presumed innocent. Even a few days in pretrial custody can jeopardize a person's employment, their housing, and their community connections, and it can increase the risk of future offending. The courts are bogged down with minor matters and administrative breaches and a culture of adjournment that has been described as an entirely unacceptable threat to constitutional rights, a denial of access to justice, and an unnecessary cost to the court system. There is a lack of legal aid funding for defense counsel, and often an absence or sparsity of disclosure at an early stage. Community supervision resources are understaffed and underfunded. Finally, Indigenous peoples, racial minorities, the poor, the homeless, the drug addicted, and the mentally ill are all overrepresented in our jails. For the past 3 years, the pandemic has also eroded many of the social supports upon which people in these groups rely. It is perhaps no coincidence, then, that it is in this same time frame that these concerns for repeat violent offending have come to the fore. These facts all combine for one troubling reality. Our court system is overwhelmed, and our society is in a crisis. Reverse onuses will not solve that crisis. New rules and definitions for repeat violent offenders will not protect the long-term public safety. Bail decisions are inherently imperfect risk assessments. Reverse onuses do not tell a judge anything they don't already know about the caution needed when a violent offender who's facing new violent charges comes before the court. That person already faces an uphill battle to release, regardless of such a label. However, reverse onuses risk a one-size-fits-all approach that may threaten the right to reasonable bail. A person who may otherwise be a consent release candidate may face delays, even a matter of days, to prepare a release plan. They may face pressure to agree to excessive conditions, and they may face pressure for a hasty and sometimes wrongful guilty plea. History suggests that, unfortunately, this will have the greatest impact on those same marginalized groups. Finally, adding reverse onuses would run counter to the clear direction from our Supreme Court of Canada in Antic and Zora. Legislative reform alone will not cure what ails this justice system, nor will it protect our society in the long term. As this committee has heard, effective bail reform requires a multidisciplinary approach to understand and, more importantly, prevent the root causes of criminality. CDAS encourages this committee to consider how the federal government can support the following measures. First, increasing community health resources and social services, particularly in rural and northern regions. Second, creating non-police mental health crisis response teams. Third, decriminalizing the possession of a small amount of drugs and providing a safe drug supply to those addicted. Fourth, mandating timely disclosure at bail hearings. Fifth, continuing to uphold the direction from Antic and Zora that pretrial release is the norm and detention the exception. In Antic, the Supreme Court of Canada opened their decision by describing the interrelation of the right to reasonable bail and an enlightened criminal justice system. An enlightened criminal justice system must be forward-looking and not overly swayed by the emotions and tragedies which are, unfortunately, its stock in trade. On behalf of CDAS, I urge this committee to favor data over emotion, to favor progress over regression, and to favor the long-term safety of Canadians over short-term reactions to tragic events. Thank you very much.
Thank you, Mr. Zargarian. Now we'll go to Melanie Webb from the Criminal Justice Section of the Canadian Bar Association.
Good afternoon. Thank you for the opportunity to appear before you today on this important issue. The Canadian Bar Association represents approximately 37,000 lawyers, students, academics, and jurists across Canada. Our mandate includes seeking improvement in the law and the administration of justice. The Criminal Justice Section is made up of a balance of Crown and Defence Counsel from every part of the country. Many of our members also frequently represent and provide advice to complainants and families of victims of crime during the course of criminal prosecutions. I serve as the Communications Officer for the CBA Criminal Justice Section, and I've been a criminal trial and appellate lawyer for the past 15 years. In 2018, the CBA supported many of the amendments to the bail regime proposed in Bill C-75. The CBA submits that when considering any further proposals for bail reform, a nuanced approach is appropriate. Any changes contemplated to the bail provisions must be evidence-based, consistent with constitutional rights, and consistent with the long-standing principles outlined in the lengthy line of bail cases from the Supreme Court of Canada. It bears reminder that all persons who come before the court charged with an offense are presumed innocent, until proven guilty. This is a constitutionally protected right. That presumption continues to apply no matter the subject matter of the offense and whether or not they have a prior record or outstanding charges. That presumption continues to attach to all persons at every stage of the criminal justice process, including the bail stage. Nonetheless, the culture of bail has often been referred to as being one of risk aversion. Yet, the Supreme Court has reminded us repeatedly that pretrial detention should be the exception and not the rule. That said, there will be times when detention is warranted, and detention is indeed ordered in bail courts across the country. Our jails are over capacity in many areas with people detained pretrial. There have been calls to add more reverse onus offenses on bail. There is already a long list of reverse onus offenses in the criminal code. But regardless of whether or not a particular offense is a reverse onus or a crown onus, crowns are well equipped with the tools necessary to argue, where appropriate, that the accused should be detained or that the accused has not shown cause why they should be released. It is not uncommon for someone to be detained on crown onus offenses. Practically speaking, whenever serious violence is alleged to have been caused by the accused, and especially cases involving firearms, the reality is that it is very much an uphill battle for an accused to be granted release, regardless of who the accused is. It is by no means easy, and by no means simply catch and release, as some have suggested. Where the Crown is of the view that the lower court erred in granting release, the Crown may bring a bail review in short order to review that decision. And when an accused reoffends while on bail, the Crown may apply for the revocation of bail. These are not unusual or exceptional situations, and the Crown can successfully argue these cases where appropriate. As the Supreme Court reminds us, the setting of bail is very much an individualized exercise. The law already provides for the consideration of a wide array of relevant factors, which are considered by experienced judicial officers in every bail hearing. Modifying the language of the bail provisions of the Code will not prevent tragic events, such as the recent officer-related shootings or violent crime on the public transit system. Instead, a focus on addressing the root causes of crime, including providing greater resources to social supports that would help marginalized and vulnerable populations, would be more productive. We emphasize especially that this requires particular attention to those suffering from mental health issues, substance abuse issues, poverty, and insecure housing. Thank you for your time, and I look forward to answering any questions you may have.
We'll now begin our first round of questions. These are 6-minute rounds, beginning with Mr. Caputo for 6 minutes.
Thank you, Mr. Chair. And full disclosure, I've dealt with Mr. Arnett Zagarian and Mr. Del Biggio in my prior work. They're both obviously well-respected members of the bar, and I anticipate that Ms. Webb also would come with that label of being very well-respected at the bar, given her work with the Canadian Bar Association. I'm going to ask you, Mr. Arnett Zagarian, my sense is that you're on the ground a lot, if you will, and by that I mean, you're at 222 Main Street in Vancouver, which is known as a fast-paced court. Is that accurate?
Yes, and probably even faster pace at Surrey as well.
Yes, these are fast-paced courts that are often dealing or triaging bail hearings. This is part of your life.
Absolutely.
Okay. Now, before I get into the bail review, would you agree that Zora and Antic did fundamentally change how we look at bail? You'd agree with that? That's okay.
I think in many cases they either changed it or reinforced what many were already practicing, that the right to reasonable bail must be protected and jealously so. So yeah, I would say that yes, for some it did change that, and for many others it reinforced what we already knew.
Right. Now, would you, as a defense lawyer, and you see trends, obviously, and you know different judges and you see trends, would you say it's harder now to get bail or easier now to get bail post-Zora, for instance?
I don't know that there is a trend of being harder or easier. I think really what the focus has become is on what really, what are these least onerous conditions? And for some people who before Zora they weren't going to get release, they probably still aren't going to get release. And so, to answer your question very briefly, I don't think I've seen a specific trend that bail courts have become more lenient. They've, if anything, likely become more focused.
Okay. Focus, the consequence of that focus, though, for instance, it might be 6 conditions instead of 12. Everybody doesn't get hit with an intoxicants provision.
That's fair.
Thing.
That's fair.
Right.
Yes.
And part of that focus, and we could debate the rightness or the wrongness of this, has been to favor release given Antic and Zora. Would you agree with that?
I think it's been a focus on reminding ourselves we need to look at the conditions that are truly necessary for the specific grounds at issue. So the one that we're most concerned of today is the secondary ground, protection of the public. And so, again, it's been a matter of first of all, are there conditions upon which this person could be released where public safety will not be substantially at risk? And if so, what are the least onerous ones? And so, in practice, it may end up being that, like you said, that person would be released without a blanket alcohol prohibition or without a blanket area restriction. But generally speaking, and I don't think I have data to support every single point here, and I think that's one of the issues the committee has said, we don't have all this data on bail, but I don't think, at least in BC, in the jurisdictions I most often practice, it's led to a trend of more likely to be released, just more focused conditions on those risks.
Okay, thank you. I'm going to ask you a little bit about Myers, the Myers decision, which I'm sure you're familiar with. Myers was a decision that considered bail review sections, and those are automatic reviews on an indictable offense at 90 days. Do you agree with that?
Yes.
Okay. And generally, there's often a change in circumstance on the accused's behalf at that 90-day threshold, as in treatment is now available or has been lined up, something like that.
That is certainly part of the approach.
And that's your job as a defense lawyer, is to set up that treatment or to arrange a surety, something like that. Is that correct?
It typically falls to the defense counsel to do all of those, all the legwork, we'll say, find a recovery house, find treatment, those kinds of things, yes.
So generally a bail review, if there is an initial detention, often they are successful where an initial application for bail won't be successful. Would you agree with that?
I don't have statistics on that.
Anecdotally, I'm talking about.
Anecdotally, I think it's hard to say. It would really come back to the specific cases, and I'm being very candid. In my own experience, I haven't seen a trend of it's more likely or it's less likely. It all comes back to, obviously, what are the issues for that person? I mean, there's going to be some where it doesn't matter how many treatment centers they may have access to, they're just not going to be released.
Yeah, fair enough. I'm going to ask you a little bit about, you talk about data over emotion.
Yes.
And I don't know about you, but I presume that everybody on this panel would agree that we're most concerned about public safety, and public safety is impacted by interpersonal violence, and firearms are two of the key aspects. And I'm putting aside intimate partner violence for now, but those are two aspects. Would you agree?
Yes, I'd agree with that.
So if the bail system is to be reformed, we talk about data, and my understanding, sir, is that there's been a 32% increase in violent crime, and that there's been almost a doubling in gang-related homicides, particularly with firearms. So if we talk about that data, I take it we can both agree that if we're going to focus anywhere, that would be a place to say, you know what, we're going to be dealing with violence and with firearms getting into the wrong hands. Do you see where I'm going with that?
Certainly, and that has to be a focus of this committee of what we do for those extremely serious types of crimes. And I think that the difficult balance is going to be striking the right approach of targeting those crimes which are clearly a danger to society, while not having, I'll call it bycatch, including the people who should not be included in those.
And you'll get no difference, you'll get no argument from me. And there's definitely a difference in somebody who's a chronic shoplifter or breaking into cars as opposed to somebody who possesses a weapon as a tool of the trade.
That's right. And just to briefly conclude on this point, I mean, one of the proposed reverse onuses is for the Section 95(1) offenses, which clearly the courts have said at that spectrum of the offense, the tool of a criminal's trade is a serious and dangerous offense. But not every offender will be in that. And so that's one of the examples of the risk where we could catch someone who should not be involved.
Well, if you are in Canada carrying a loaded firearm, generally it is a weapon. It is a tool of the trade, I would argue. But in any event,
it may be. I would just point to paragraph 82 of the Noor decision, which talks about the other end of that spectrum, the responsible gun owner who would fall under that. But
you wouldn't get any argument from me on that paragraph.
Thank you, Mr. Caputo. We'll next go to Ms. Diab for 6 minutes.
Thank you very much, Mr. Chair, and welcome to our witnesses. Thank you for coming today as we continue our study on bail reform. Maybe one of our last sessions today, so very much appreciate the immense experience that you all have and that you're all sharing with us. Ms. Webb, I want to ask you, you have 15 years experience yourself personally, but also the Canadian Bar Association amongst its various members would have tremendous experience. You said that the Canadian Bar, and I wasn't there at the time, but supported Bill C-75. Can you describe what Bill C-75 did and the impact it had on our bail system, in your opinion?
Yes. Bill C-75 implemented a number of changes, not only to the bail regime, but many other aspects of the criminal justice section. And we made extensive submissions on this. We did support many of the amendments in the bail regime. We felt that they would lead to more expedient hearings while still being consistent with the existing case law and constitutional concerns. So, for example, we supported the codification of the restraint principle, the latter principle, which was already codified in the criminal code, as well as section 493.1, which directs the judicial officer to give primary consideration to releasing the person at the the earliest reasonable opportunity and on the least onerous conditions appropriate in the circumstances. And I'm referring again to the restraint and to the latter principles. Section 493.2 required consideration of the overrepresentation of Indigenous people on trial, as well as other vulnerable populations who have been overrepresented and disadvantaged in the criminal justice system. We also supported changes which would explicitly discourage the use of cash deposits and sureties, and that's based on many judgments and reports over the years which have commented on the over-reliance on surety bail as a form of release. We also supported the diversionary mechanisms, including judicial referral hearings, which I should note that just based on my own experience, I don't think that we have seen as much of that use as much as I think could have been done. And we also supported, in particular, expansion of police powers, which would allow police to release an accused on arrest, which would reduce overall the number of bail hearings and hopefully the number of people in detention in custody. We also noted that Bill C-75 also did make it a bit more difficult for people charged with domestic violence-related incidents and already had a record for such violent offenses. And that was something that we made submissions on as well. So we should, that was the overall import of the changes to the bail regime as a result of Bill C-75.
Thank you very much for that. That was very helpful to clarify all of that. You said, as well as other witnesses have said, that any amendments that are to be made need to be made based on evidence, on statistics. My question to you is, are you familiar with, do you have evidence from the Canadian Bar Association or anywhere that you would have gathered or others would have gathered that suggests to you that we should be making amendments, and if so, what type of amendments?
So the Canadian Bar Association, as far as I'm aware, we do not ourselves collect statistics. We have in our submission made reference to statistics from Statistics Canada, which are accessible online. And we included that specifically to provide some clarity regarding, whether or not there has been an increase in crime, and if so, what kinds of crime and what might be the reasons for that. So I can't speak specifically, as I'm not a criminologist, I'm not a statistician either. I'm simply a criminal defense lawyer and someone who participates quite actively in issues on law reforms and advocacy. However, we would suggest again that if there are going to be changes to the bail regime, that we do not react. Again, I would sort of echo the words of my colleague, Mr. Arnett, that we do not react based on emotion and that we do not react instinctively on very tragic emotional events, but that we really look at the literature. For example, the brief that was submitted by Dr. Nicole Myers, I felt was very helpful earlier on these committee meetings, and I felt that might be a very good source as a starting point.
Thank you for that. Can I ask you, Mr. Greg Delbigio, the same question? You also alerted to the fact that we should have, that it should be evidence-based. And actually, you actually started with, and I kind of appreciated that the study of the bail system is not new. And in fact, it's been decades old. Do you have any recommendations for us on this committee in terms of if we need what amendments we should make, and what kind of sort of evidence or stats have you yourself or people around you seen based on your experience?
So we don't keep statistics. We're just not equipped to do that. And in my experience in sitting on various committees and attending various meetings where these issues are discussed, it's always the governments, the institutions that are best able to gather statistics. And of course, what is kept depends upon what it is that you want to measure. And it takes time to gather statistics, and it takes competence with respect to how to do it. But I do think that these issues, we're talking about people's liberty, and if you are thinking that more people should be in jail while presumed innocent on a pretrial basis, and if there is if it's suggested that there's a need for that, I suggest that justification should not be found on impression. It should be found on demonstrated need as found in statistics.
Thank you. Thank you, Ms. Diab. We're out of
Thank
time.
you very much.
Next, we'll go to Monsieur Fortin for 6 minutes.
Merci.
Thank you, Mr. Chair. I would like to thank the witnesses who are with us here today. Their being here is much appreciated. As my colleague, Ms. Diab, has just said, this is an important topic, and this is likely our last meeting hearing witnesses, so what you have to say to us truly counts. We're facing two different ways of seeing things, and you can see that. You play important roles in the legal system, so some feel that the basic doctrine, that you automatically release people, should be applied across the board, detention being an exception. Others tell us that, look, there are cases where we really do need to remand people because it would be dangerous to leave certain persons at liberty. Mr. Harnand told us earlier that crimes with firearms, this is an important thing to keep in mind, to weigh. And also, repeat offenders, difficult to justify releasing them and facing possible setbacks when they reoffend. So there are situations where, well, at least this is the way I'm thinking. There are situations where people do need to be remanded, and others where they really should be left free. It's a case-by-case matter, I think, and courts must make decisions based on the facts before them. I think that's a wise approach. But all right, so I've said enough. Here's my question. There are a number of elements that would lead any court to make a decision in one way or the other, and the decisions made by the legislator play into that. At the federal level, we recently passed C5, which provides for withdrawing minimum crime being held after a crime for certain situations. For example, if you shoot a firearm in certain conditions, you wouldn't necessarily have a specific sentence applied to you. We decided that minimal sentencing no longer applied to that. For example, now according to you, Mr. Arnott, does this affect the way a court will weigh situations when they are deciding whether a person should be let go on bail or not? Thank you for your question. To ensure that my answer is clear, I will speak in English, but thank you for the question in French.
This question, I heard you ask this question of another witness earlier, and I thought it was a very important one. You addressed the issue of bail hearings being very much case by case. Different facts will impact the outcome. And I think what the abolition of mandatory minimum penalties has done has focused each sentence on the case by case issues. And to briefly answer your question, no, it has not been my experience that removing mandatory minimums has led to less harsh sentences or judges treating certain crimes as less serious. The common law already explains that the way judges must treat this is by examining the maximum sentence. And so removing mandatory minimums does not, in my sense, send any message that certain crimes are not as serious as they were before. It only recognizes that in these, there are so many different kinds of, there's a different array of circumstances that can lead to the commission of an offense. And to use, again, the example of possession of a prohibited firearm, it is very unusual to see any sentences well below the previous 3-year mandatory minimum. That still, in effect, is being treated, at least in BC, as a de facto mandatory minimum.
Mais n'êtes-vous pas d'accord avec...
Yes, but wouldn't you agree with me that the legislator has nevertheless specified by abolishing mandatory minimum penalties? Well, you know, it has to mean something. It can't have been enacted for nothing. And we have seen cases in Quebec, in particular, recently in the last months, where a court would ask attorneys, in this case, given the abolition of mandatory minimum penalties, I'd like to hear you on this. I'd like to hear your opinion on this matter. And lawyers said to plead, especially on the defense, they would say that this, of course, indicates that this is a less serious matter than might be thought. And, of course, the Crown would say differently. But isn't there a clear indication that, and if you say there isn't one, then what's the use of having abolished mandatory minimum penalties if there's no effect on the way justice is meted out?
The different circumstances that can lead to that offense. It's not at all saying that broadly this offense is less serious. It's explaining that depending upon the commission's, the circumstances leading to this commission, including the actual facts that led to it and the facts of the specific offender, a different sentence will be appropriate. And it's, in my respectful view and based on my experience, not at all sending the message that a crime is less serious.
Monsieur Arnett,
If I understand you correctly, Mr. Arnett, you are a defense attorney, correct? Yes. And if you represent an individual who is charged with a crime, having committed a crime with a firearm, you would ask the justice to liberate your client, to let them go on bail. You have others who would say that this is very serious. There's a firearm involved and the public safety has to be taken into consideration. Wouldn't you plead to the effect that the legislator has decided that the mandatory minimum is no longer to be applied and that would affect how you would argue?
No. No, I would not. I don't think so.
Thank you, Ms. Hereford. Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I'm glad to have the opportunity to drag us back to the topic in front of us, which is actually bail and not mandatory minimums. I want to ask Mr. Del Biggio, you mentioned bail supervision programs being recommended since 2016. I wanted you to talk about what you believe the impacts of having more bail supervision programs available would be.
Bail supervision programs can help address risk. And to the extent that risk arises because of instability in a person's life, either through housing issues or addiction issues or poverty issues, all of those things can be addressed through bail supervision rather than jail. Jail is a very, very blunt tool through which to address risk, and it should be an absolute last resort. And it's not cost-free. It's not financially cost-free. It's not socially cost-free. And I think there are people who have done cost comparisons about monitoring people in jail as compared to out of jail. I suspect that the out of jail monitoring is cost less financially and is certainly socially advantageous.
I believe a greater availability of bail supervision programs would help address the overrepresentation of Indigenous people, marginalized people in pretrial detention?
I have no doubt, because part of a submission on bail as a defense lawyer is to propose a plan, and that is going to give a judge comfort that a person is going to be stable in their lifestyle and such that they can abide by bail conditions. And if that stability does not otherwise exist, and if it can be provided through bail supervision, then that is going to increase the chances of people getting bail and being successful while on bail.
Thank you. I want to turn to Ms. Webb. We've had some before the committee and certainly in the media, some allegations that judges or justice of the peace don't always have full information about the person being charged when they're making bail decisions. Can you comment on whether that's been your experience or the Bar Association's experience? Do judges actually have the information they need, and does that include administration of justice offenses?
Yes. Well, I mean, I can indicate, speaking even as a defense lawyer, having had experience in bail hearings, certainly in Ontario, the practice is for a Crown in a bail hearing will invariably supply the court with a list of the accused criminal record, a list of any outstanding charges. We even have Crowns who will supply occurrence reports, which may go to establishing a pattern of continuing criminal conduct. And that, of course, can be a little bit controversial, obviously, to the defense. It is not unusual for judicial officers, justices of the peace, or judges on bail review to make various inquiries of the Crown and the defense during a hearing to satisfy themselves of any lingering concerns or questions that they may have. And we allude to this in our written submission, but we're not aware of any evidence that there is some kind of widespread problem that judicial officers are routinely receiving less than adequate information, or that this is an issue that requires specific correction in the code.
Indication that administration of justice offenses previously would not be available when it's appropriate to the person making a decision on bail?
So that, of course, would all be known to the Crown as well, and certainly that often figures prominently in Crown submissions. Administration of justice offenses will show up on a criminal record. Of course, I don't think I need to remind this committee of the kinds of the discussion that's made by the Supreme Court in, for example, the Queen and Zora decision, which talk about the issue of administration of justice offenses, which can actually make it far more difficult for people to attain bail. So we don't actually see any indication that this is, again, some kind of significant issue which causes problems for judicial officers to make informed decisions.
Thank you very much for clearing that up. I want to go to Mr. Arnett Zagarian. I want to go back to the question of bail supervision programs and their impact on both individuals and on community safety, and ask you a similar question that I asked to Mr. Del Biggio before.
That's about whether this would help reduce the rates of over-incarceration. Is that
both over-incarceration and also the contribution to the public safety and to the public views about confidence in the justice system?
Yes, thank you very much. And my short answer to those is yes to both. These types of programs, I'll say in BC, we don't have quite the robust kinds of programs that we have in Ontario with the John Howard Society. But I will say, just to speak anecdotally for a second, I've had the privilege of liaising with the John Howard Society for a client who's based out of Toronto with BC charges. And I have to say, I was resoundingly impressed with how comprehensive their services are and what kind of assistance that could provide to other similarly situated accused who have no resources, perhaps mental health problems and addiction problems. Some of the challenges we see in forming a bail plan that is first realistic and second of all that will actually protect the public safety is issues such as overcrowding in recovery houses, a lack of availability of recovery houses, and a lack of supervision. In other words, you're left in this predicament where you're presenting to the court what may be an ineffective plan, but these types of programs could certainly greatly assist that.
Thank you. Thank you, Mr. Garrison. Next, we go to, I think it's Mr. Van Poptov for 5 minutes.
Good. Thank you. Thank you, Chair, and thank you to the witnesses for being here. I think this will be a question for Mr. Del Biggio, but perhaps perhaps some of the others would comment as well. You had said that it was important that, or you noted that there was a lack of data around pretrial incarceration. We heard that from other witnesses as well. And I would like to have your comments on that. What sort of statistics and data should we have that we do not have at the moment? I know some of our earlier witnesses had pointed out that that more than half of people who are incarcerated at the moment are in pretrial incarceration. So I'm wondering, like, how long are they there? How many people eventually do get bail? And we've also heard evidence about a culture of adjournment. So how much of that is the cause of lengthy pretrial incarceration? So my question generally is, what data should we have that is missing at the moment as we parliamentarians try to establish public policy around this?
Yeah, thank you for the question. Certainly there's some data, and with respect to how many people are held pre-trial. But I think that if you're trying to drill down into public safety, I think it's a different kind of data, and particularly if it's public safety with respect to what happens when certain people are released on bail. Really, what the data that you would need is upon rearrest, was the original bail decision the system operating as it should, and this simply and the new arrest being simply an unforeseeable risk, or does it reflect some sort of a problem with the original bail hearing that maybe could have been corrected by way of an appeal, or does it reflect a gap in the existing laws governing bail? And I suggest that that the existing laws governing bail give a prosecutor all the tools that they need to oppose bail in serious cases. And where there are people who are out on bail and they are picked up and charged with new offenses, it does not necessarily mean that the existing laws aren't working. And so how to measure that? Again, because I'm a lawyer and I'm not a criminologist or a statistician, I can only guess as to best how to measure that. But I think that there are people who are in the business of measurement who could probably answer that question better than I.
Just to be clear, I wasn't actually asking you for the measurements, but only what sort of data is missing, what gaps are there? Maybe I could go over to Mr. Arnett Sargarian, and if you could comment on that.
Thank you very much. It's hard to say what's missing. It's a difficult question to answer, but what I would say, some of the points that you raised, knowing how long a person on average will spend in pretrial custody, and I think importantly, we talked about the culture of adjournment, and that's been some subject of discussion here about, well, who is responsible for that? And it's a difficult debate to engage with, and I think it misses the issue. Instead of pointing fingers, but looking at, well, why is this case being adjourned? Is it because of a lack of court resources? Is it to find housing? Is it to find treatment? Is it defense unavailability or Crown unavailability? That can help us focus on where we can eliminate one of the barriers to access to justice, that being the right to reasonable bail in a reasonable time.
Thank you, Mr. Arnett Sargarian. I have another question for you. You had said in your testimony, and I've also read somewhere that you've written, that any policy that we might introduce around bail reform must align with the consistent direction from the Supreme Court of Canada, that reasonable bail is the norm and detention in jail is the exception. But certainly there is room for some exceptions. I'm thinking of the person who has now been accused of murdering Constable Pershella, who was he was a repeat violent offender. He had been charged and I believe convicted of intimate partner violence in the past. And he was out on bail, pending trial on similar types of charges. Certainly that should have been an exception. What are your comments about that?
I think I want to come back to one way that I've described the bail hearing. This is not my own description, but a common description, that it is an imperfect risk assessment. This is, I tried to find the actual transcripts of that hearing. I couldn't find them before this, but as I understand, it was described, I may be paraphrasing, as an iffy or a close call on the bail review that led to that release. What does that tell us? It tells us that this individual did not necessarily need an additional reverse onus to be detained. That may not have made the difference. It was already very close. And so without knowing what the specific judge was looking at in that case, it's hard for me to say, well, this would have led to the circumstances that could have saved the officer's life. But it's the challenge we face in bail that it's not, we're not able to say, was this a right or a wrong decision? It's a risk assessment. And what judges are all striving to do is achieve that balance of protecting the public, but upholding our constitutional rights.
Okay, good, thank you. So do you have time for another question?
No.
Okay. Good thought.
Thank you. Next, we'll go to Ms. Briard for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair, and good afternoon to all our witnesses. Thank you for being with us here for our likely last meeting on this topic. My question is for Mr. Arnett Sargarian. I'm concerned by the matter of public safety. I'm also concerned by the need to ensure that constitutional rights to liberty are respected. In BC, the Crown Prosecutor indeed has brought in a new directive that shifts the bail system in BC. Among the main changes to the policy right now, the provisions obliging Crown prosecutors to request detention only if there is a request for it in the sentencing, and that is no longer to be the case. So I'd like to hear you on this. Will this help us with releases on bail?
This is about whether the removal of the previous policy of considering whether the overall sentence will lead to incarceration. This is what the question's about. I would say, just for reference, this was a removal. There was a previous policy in which the Crown prosecutor would consider if someone is unlikely to face a jail sentence, whether they should seek detention. I would say that should give us some concern. The fact that someone could be detained on extremely minor matters or relatively minor matters simply because they are a public safety risk gives us some concern. It's, in my submission, not consistent with the theme or the guidance from the Supreme Court of Canada, and it leads to the obvious problem that someone could serve a longer time in jail than they would ever be sentenced to.
Merci.
Thank you. And what leads people to disrespect conditions when they are on bail? What could we do to ensure that they don't breach these conditions?
To see who will follow their conditions and how and why. What we can see, though, and one of the challenges that I think will face this committee is a lot of this is in the provincial jurisdiction, but what we need is cooperation between the governments because this issue is simply too important. We need to look at providing these resources that we know can address the underlying root causes of criminality: housing, drug treatment, mental health treatment. All of these aspects, they're very broad. They're broad terms, but we need to dedicate our resources to preventing this from ever happening. And I think part and parcel of that will help prevent future breaches, including increased supervision, including increased access to those treatments on, even hopefully before they're involved in the criminal justice system, but afterwards as well. And we're never going to be able to help every single person and prevent any breach, but that will go a long way.
Merci.
Thank you. Yes, indeed, I agree with you that the more we're able to offer services and set up services to help these people, the better we'll all be. What's the effect of remand, whatever its duration, on people who, let's say, have mental health issues or addiction issues?
Dr. Nicole Myers and others from various organizations who have talked about the statistics and the impacts of pretrial detention. But for those individuals with those types of concerns, pretrial detention centers are a harrowing place. They are for anyone, but particularly for them. Going through withdrawal symptoms in that kind of an environment, undergoing a mental health episode, not only is that a threat to their own safety, but to all the others in there, whether they are staff or fellow inmates. So it's not going to be a solution to the problem. It will likely make matters worse for that individual and others, and just as importantly, for our society when they come out.
Merci.
Thank you.
Thank you, Ms. Briard. We'll next go to Monsieur Fortin for 2.5 minutes.
Merci, Mr.
Thank you, Mr. Chair. My question is for Ms. Webb. Ms. Webb, in your opinion, crimes committed with firearms, are these the sort of crimes that we should be more stringent about before we release people on bail? And should that be the case, what criteria should the court take into account in such cases?
Well, thank you very much for that question. Fortunately, the Criminal Code actually already does specifically have specific provisions for offenses that involve firearms, and that is actually codified in the bail provisions. I know that one of the proposals, I think at large, this may have been alluded to in the Premier's letter, or just more specific, more generally, is whether or not there should be another reverse onus, for example, on possession of a firearm. And without specifically coming down one way or the other as to whether or not there should be a reverse onus on that specific offense, we address in our submission as to the fact that the circumstances of possession offenses can actually vary, and there can be cases in which it's fairly clear cut that someone may be responsible certainly for possession of the firearm, but there are others in which there's a much more tenuous connection between the person charged and the actual item, because they may simply be an occupant in a vehicle, for example. They may be just simply an occupant in a household. So in terms of, I can just say, just generally speaking, I think that it's fair to say that any time there are offenders, or sorry, I should say accused persons who come before the court and they are charged with crimes of violence, crimes involving offenses in which there's been a use of a firearm, it is very much an uphill battle for that person to be released. And I would just strongly encourage this committee not to be swayed too much by anecdotal evidence, and that have been suggested, I think, in prior meetings. But that generally speaking, if you were to go into bail courts in Toronto, for example, Toronto and Peel, which are very, very busy bail courts, you would see that day in and day out, experienced judicial officers are very well aware of the principles of bail and are very well aware of the need to balance public safety and confidence in the administration of justice. And by and large, they carry out that responsibility very well.
Thank you.
Merci, Madame Webb.
Thank you, Ms. Webb.
Thank you for that. Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I want to go back to Mr. Arnett Zergarian. In a lot of the public debate on bail, there's been discussion about so-called repeat violent offenders and the ease of them getting bail. And of course, I think you probably agree with me, there is no such category in the law. That makes it hard.
No, there's not.
But in your experience, those who might colloquially fall in that category, do you find that it's easy for them to get bail?
Certainly not. I mean, to put it bluntly, that's really not the case. You've got to come with a comprehensive plan, and again, these things are always on a spectrum. If you have someone who has a series of recent serious violent charges, that's more than an uphill battle to release. That's almost a foregone conclusion they'll be detained.
And I would ask the same question to Mr. Delbecchio.
So in my experience, these people are being detained, but also, listen, transcripts are available from bail hearings. So if people can point to specific bail hearings and say, this bail hearing illustrates a problem, I urge people to get the transcripts to understand concretely what it was that took place at the bail hearing and why a person was released. I mean, these things should not, these kinds of decisions should not be made on the basis of impression or emotion or guesswork when data is available. The data of transcripts is available. And I urge those who suggest that there's a problem to obtain and present the transcripts that illustrate a problem.
And finally, I know almost out of time, I want to go to Ms. Webb. We've heard lots of talk about how the Supreme Court has said that people should be released at the earliest opportunity on the least conditions. How do we square that with a very large number of people in pretrial detention in this country?
Well, yes, thank you for that. And I realize I have very limited time to address that question. Just one thing I just wanted to note, which I don't think has been mentioned earlier, but during the early days of the pandemic in 2020, there was a great concerted effort between the Crown and the Defense Bar in trying to consent to release and fashion conditions that were reasonable to try and, particularly when there was a lot of uncertainty, there was no vaccine available. The conditions of jails are, aside from being very, very poor generally, are certainly not amenable to people who are residing in closed spaces and unable to self-isolate. What I've seen, I would say that, after the initial months of 2020, there's been a little bit more of a reversion back to greater opposition to bail and opposition under reasonable conditions. And so maybe I'll just suggest that I think we are seeing a little bit of a swing. I can't speak to all jurisdictions in the country necessarily, but I have seen that. And again, I really refrain from making anecdotal remarks, but that has been the general experience, certainly in the Golden Horseshoe area in Southern Ontario. Thank you.
Thank you, Mr. Garrison. That concludes the first panel. I want to thank all three witnesses, especially the ones that are from Vancouver. Thank you for appearing and coming down. We'll now suspend for about 1 minute just to do a couple sound checks, and then we'll begin the second round. For the second hour of the study on bail system, I want to welcome our witnesses, Michael Spratt, Sylvie Brodelet from the Attorney at Law from the Association of Advocates of Quebec, as well as, Mr. Spratt as an individual. He's a partner at Abergale Goldstein and Partners, and Kevin Davis, Mayor of the City of Brantford. Welcome. Those that didn't hear me before, so I just use some cue cards. So when you're down to 30 seconds, I'll raise that, and when you're out of time, I'll raise the red one. So just be mindful of time. Hopefully put your mics on the correct channel, just so you can your headphones on the right channel so you can hear. And on Zoom, Ms. Bordelais, just make sure you've got your interpretation to the right language so you can hear everyone. And Monsieur Fortin, I've been told the sound checks have been made. So we'll begin.
Made, but is it okay?
I've been told it's okay.
Thank you.
So we will begin with Mr. Spratt for 5 minutes.
I'm certified a specialist by the Law Society of Ontario in criminal law. I'm a partner at AGP Law here in Ottawa, and I've been practicing exclusively criminal law since 2005. Every discussion about our bail system must start with the fundamental constitutional principles that have been enshrined in the Charter of Rights and Freedoms, the presumption of innocence and the right not to be denied reasonable bail without just cause. We must remember that people denied bail are presumed innocent. We should not seek to punish people before they have been found guilty. And pretrial detention is punishment of the worst kind. I want you to imagine a jail so devoid of humanity that guards stand idly by while a pregnant woman gives birth in her cell. A jail so lawless that guards can brutalize inmates and then cover up the abuse with impunity. A jail so overcrowded that inmates are forced to sleep in a damp shower cell. A jail so dirty that clothing and bedding are stained with urine, feces, blood, and there's bedbug infestations and other unsanitary conditions that lead to untreatable infections. This isn't hyperbole, this is reality. More than 70% of Ontario's jail population is made up of individuals awaiting trial. We lock people up because they are poor, homeless, addicted, sick, or marginalized. Sadly, rehabilitation programming, addiction counseling, and mental health treatment are non-existent for most of those inmates on remand. The dirty secret of the justice system is that people usually come out of jail in worse shape than when they went in. Our jails are increasingly expensive factories of suffering that interfere with rehabilitation, cut accused people off from family and community support, result in homelessness and unemployment, and make our communities less safe. Most disturbingly, pretrial detention results in a perverse incentive to admit guilt, to escape those horrendous jail conditions, rather than wait months for a trial. I've seen this on many occasions. Any study of the bail system should examine these issues. We do need to talk about reform, but I expect that's not the type of reform or the type of questions you'll be asking me about. The current discussion about bail and firearm offenses has been driven by some very high-profile tragedies, like the killing of OPP Officer Pershala, and most recently the shooting deaths of Edmonton police officers Constables Jordan and Ryan. It can be easy to ignore some important facts in the face of such tragedy. So I briefly want to start with some facts. 1, crime statistics are very complicated. 2, historically speaking, we live in one of the safest periods in Canadian history. Violent crime rates have been declining for years, and we've seen an 11% drop since over the last 20 years. Now, there has been an increase in the rate of firearms-related offenses since the year 2000, but the use of firearm offenses and homicides has remained relatively stable over the last 20 years. And according to StatsCan, there was a decrease of almost 10% in gang-related homicides in 2020 and a 5% decrease in firearm-related violent crime in 2021. 3, there's not an increasing trend of on-duty police deaths. 4, pretrial detention increases rates of recidivism. 5, Bill C-75 did not contain catch-and-release bail policies. There's no such thing. This type of language is a political grift. Bill C-75 legislated recent decisions from the Supreme Court, like the principles of restraint, and actually let police officers impose stricter bail conditions when they release individuals. And it reversed the bail onus for many offenses that involve intimate partner violence. 6, firearm offenses are taken very seriously in our courts. In my experience, police rarely release these accused, unless the accused is a fellow police officer. Crowns rarely consent to that release, and bail hearings are always lengthy and hotly contested. 7, reverse onus bail for firearms offenses is most likely constitutional, and it might prevent some offenses. 8, but it won't deter offenses, just as increasing sentence length doesn't deter offenses. 9, reverse onus provisions in firearm bail would not have prevented the deaths of Officer Pershala, Officer Jordan, or Officer Ryan. The solutions to be found are not in changing bail law, but looking at increased funding for access to justice, upstream social supports, and bail enforcement. There is a crisis in our bail system, but not the one that you think. Our bail system is not overly lenient. The catch and release slur is not true. Recent legislation did not cause the recent tragedy, and I urge you to look at the realities and the evidence and not use the criminal justice system as some sort of political wedge.
Thank you, Mr. Spratt. We'll next go to Madame Bordelais for 5 minutes.
On behalf of the AAADCQ, the Association of Quebec Prison Lawyers, I thank you for inviting us to appear before you today. Quebec's prison lawyers are a small group of professionals who, for more than 30 years, have represented incarcerated clients held in prisons and penitentiaries. Here, I will focus specifically on incarcerated people who are awaiting trial, remanded persons who have been denied bail or who have waived bail. To avoid repeating what our colleagues from the defense have said, I will speak mainly about what actually takes place in prisons where people presumed innocent are held behind bars. The following statistics are posted on the website of Quebec's Ministry of Public Safety. They provide an overview of the current situation, how it has evolved over the years. I would like to point out that the sharp drop in the 2020-2021 figures is due to authorities' efforts to control the spread of COVID-19 by avoiding overcrowding prisons. I won't go over the statistics in detail. You can surely see them. 2020-2021 statistics indicate that 26,000 and some people were incarcerated, about 378 per 100,000 of the population. 50% of them had been charged. 10 had medical health problems. More than 73% were taking prescription drugs. 11% were women. A little over 4% were Indigenous, and nearly 3% were Inuit. In 2018-19, before the pandemic, 25,555 people were in detention, 12% women, 4.4 Indigenous, 3.5 Inuit. 8% had physical health and 11 mental health issues. 35% were on medication, 2.6 at risk of suicide. 91% were single. 76 did not have a high school diploma, 76% then. 59% were living alone, and 36% did have a criminal record. The most frequent offenses leading to incarceration were breach of a recognizance or probation order, possession and trafficking of a drug, and theft over $5,000. 55% of these people were actually acquitted. 43% did remain incarcerated, and 2% were sentenced to community work. The average length of stay is 55 days in pre-trial detention. That's the case in 24% of the Montreal in prisons and 22% in Rivière-des-Prairies prisons, 12% Quebec City. The death of incarcerated people is not always made public. One case that stands out is that of a young man who should have been released based on a judge's order granting him parole, but who instead died on Christmas Eve 2022 in the custody of Quebec's Correctional Services. In the same year, another individually provisionally incarcerated, also in the custody of Quebec's Correctional Services, was killed by a fellow inmate. This tells the grim story of detention conditions in some provincial institutions. TC Media obtained data to the effect that there were 73 violent deaths in Quebec prisons between 2010 and 2015. Death by suicide remains the leading cause of inmate loss. Taking the statistics that I showed you earlier for 2022-2023, 43 people attempted suicide, and 7 of them actually died by suicide. Keep in mind that this is for 22-23 as of the 21st of October 2022. So those are the deaths. I was unable to determine whether these deaths occurred among detainees or remand prisoners, but all detention centers were involved, including those that hold women, and regardless of the size of their populations. This points to the profound distress of people in prisons, particularly given staff shortages that give rise to detention conditions that resemble torture. Let me remind you that class action suits were allowed to go forward and were won, in particular because such treatment that resembles torture is still underway in some of the provincial prisons. Right now, judges focus on their areas of expertise, and that is why they have decided we should give them the ability to decide who should and who should not be released on bail.
Mr. Davis, Mayor from the City of Brantford.
Thank you very much, Mr. Chair, and I thank you for inviting me to this committee hearing. I am the Mayor of the City of Brantford. I was elected in October 2018 after having practiced law for 38 years. Now, I was a civil litigator. I did not practice criminal law, so I'm not coming to you as an expert in criminal law. I don't pretend to be. However, I'm here to speak on behalf of my community and many of the residents in my city who are very concerned about what they see as a deterioration in social order and what they're experiencing in their daily lives. And fortunately for most, it does not involve exposure to violent crime. We read the headlines, we see it, there is violent crime that occurs in our community, but what most residents see in their daily lives is a very visible increase in what I'd call non-violent crime. They see their cars being broken into multiple times. Their homes and property are being vandalized and stolen. They see open drug use and open drug dealing. And they see that our local police service, led by Chief Davis, who I believe testified in this committee earlier this month, they see that the police doing an excellent job investigating, making arrests, and they see we're a relatively small city, and so people generally are known. They're seeing people who commit these types of crimes being released multiple times, even in the face of many prior breach of probations and breaches of prior release orders. And I can give you a couple of examples, and I know the committee has distributed some of what are Chief Davis. These slides are from actually Chief Davis and the Brantford Police Service. They refer to 10 of the most what the police service call prolific offenders. And there are a couple of there's an example of one who has had at the time the survey was done, 73 substantive charges, 9 failures to comply, 25 breaches of probation, multiple releases, almost 20, in excess of 20, but continued to commit admittedly nonviolent offenses. And it was interesting, last year we actually had an individual in the court system, he pled guilty to several break-and-enters. And he actually said during his sentencing that he remarked he'd been arrested 8 times in the previous 12 months. And he felt the system bore some responsibility for his crime spree for failing to keep him in custody. An offender mentioned that. We had another individual in our downtown seen on multiple surveillance videos across social media, destroyed $70,000 in plate glass windows. Was arrested very quickly, was then very quickly released, then went out to destroy another $20,000 worth of plate glass windows later in the day, rearrested, released, and then his spree was then brought to a halt because he committed a more serious criminal offense, and so he was detained. And I realize I'm giving you ad hoc incidents, but this is what citizens are experiencing on a pretty much weekly and daily basis. And they're becoming disillusioned in the judicial system. They're losing confidence in the judicial system. Yes, they use words like revolving door of justice, but that reflects a perception that the judicial system is not protecting them, not protecting their property. And I'm very much concerned as a lawyer what that will do over time, a gradual erosion of the value of rule of law, that law applies to everyone equally, that there are consequences for those that break the rules, and that people not take the law into their own hands. And in fact, Chief Davis just recently commented in a newspaper article this week in Brantford that he's very concerned about this growing frustration that residents have with the judicial system, and in particular bail. And he's very much concerned about there's talk in social media of vigilantism. And he's very much concerned that over the course of time, if the erosion continues that people have in the judicial system, that it could lead to that. We would obviously hope not. Now, I'm not advocating for people to be kept in jail more often and more frequently. And I have some other suggestions, albeit provided in a non-expert fashion, that I'd be happy to provide if asked questions. I'm running out of 5 minutes. But I wanted to, in my first 5 minutes, convey to you a general feeling across my community. It's the number one complaint and inquiry I get in the office of the mayor week in, week out over the last 4 to 5 years that I've been mayor. There's no other issue that causes as much comment and directs so many comments to the mayor's office asking that we do something.
Thank you, Mayor Davis.
Yep.
We'll now go to our first round of questions, beginning with Mr. Moore for 6 minutes.
Okay, thank you, Mr. Chair, and thank you to our witnesses on this panel for your valuable input into this important study. Mayor Davis, I'm going to begin asking you a question. I also bring greetings from your Member of Parliament, Larry Brock, who's a regular member of this committee. So you heard today, we've heard from some individuals who seem to take the approach, nothing to see here, there's no problem. And incredibly, I heard a witness say, there is no catch and release. I don't know what you call it when someone is caught and then released, other than catch and release. And screaming from the headlines in your own community, I see a release from the Brantford Police Service just today. Thursday, March 23rd, 2023, they say, home invasion robbery. Investigation revealed 4 male suspects armed with firearms entered a residence, assaulted, robbed, forcibly held 2 victims before fleeing the scene in a vehicle driven by another suspect. Of the 4 suspects, 5 of them, of the 5 suspects, 4 of them, 4 of the accused, are in violation of a number of judicial release orders, including multiple firearms prohibition orders. So 4 out of the 5 are in violation of judicial release orders. And this is at the crux of the problem that your community is rightly talking to you about, my community in New Brunswick is talking about. We're not talking about a vast number of offenders. We're talking about a small number of offenders that come into contact with the system, are irresponsibly let out on bail when they should be held in the interest of public safety, and then go on to recommit a crime. The Toronto Police Service provided us with statistics about individuals who are arrested on a firearms offense, receive bail, arrested again while on bail for a subsequent firearms offense, and receive bail again. So when you talk about a revolving door, and I agree with you 100%, I wonder if you can expand on that and maybe speak, you may not want to go into details, but speak to this issue that I just raised, and is this the type of thing that your community is concerned about?
Yeah, our community is very concerned about it. You heard previously from Chief Rob Davis and also Chief Darren Montour from Six Nations. They're both very concerned about it in terms of public safety. And I think their concern is justified. Has the system drawn a proper balance between protecting the public and protecting the rights of individuals who've not yet been convicted? And there's a growing perception in the community, certainly in mine and the surrounding area, that balance is out of kilter, and that the interests of those who clearly are of a criminal bent from their records, that their interests are receiving greater consideration than the interests of those who want to see themselves protected by the system. And, you know, when people lose confidence in the system, you see the broken windows of police, the broken windows of policing. If people see that there aren't consequences, then they begin to question whether they should follow the rules, because that's what rule of law is all about. And if we depend on a rule of law system that says to somebody that let me get this straight. Our rule of law depends very much on most citizens obeying the rules and acting as lawful, proper, responsible citizens. As soon as you have to police everyone, your system's going to break down. And that's my concern, that we are seeing a general increase in this kind of activity, whether it's very violent or whether it's nonviolent. And it's causing people to question the administration of justice. And I wonder, what's happened to 515.10c? Isn't that one of the three grounds? And you never hear any conversation about it, or very little conversation about that. There seems to be lip service paid to it. And I think certainly it would be worth, I suggest, the committee to look at that section. Is there a need to expand the subsections to enhance that so that it has greater importance and is a consideration? Also, we've experienced in our community many problems with the surety system. And Chief Davis in the same article talks about the prospect of professional sureties. And the issue of sureties, and that's, I think over time the system has replaced incarceration with sureties that are supposed to monitor and control the behavior of the accused. And you have many sureties that don't take their responsibilities very seriously, because there's really no consequences in the system for those that do not do what they're supposed to do as a surety. And I certainly encourage the committee to consider tightening up the rules when it comes to sureties to make that system more effective and more responsible.
You're not alone in this, in that we see that 13 premiers, all the premiers from across the country have, and they involve every party. This is not a partisan issue. At the provincial level, they've all called on the federal government to play its part in addressing what I consider to be a broken bail system, one that would allow repeat violent offenders, particularly when it involves gun crime, to be back onto the streets of your community and others across the country. So your police they've done research. They've looked at some of the individuals. I think you said it in a way that hasn't been said before. We rely on most people doing the right thing. We can't have, and that's, no one is suggesting at this committee that I've heard that most people are doing the wrong thing. What we're saying is there's a small number that have to be addressed, but that small number can have devastating consequences. For example, with Constable Pershella that was recently killed over the holidays. So do you want to speak a bit more to some of the suggestions or data that was provided around the prolific offenders that you find in your community and what we can do to address that at the federal level?
Unfortunately, Mr. Moore, we're like over a minute, but I'll give you 10 seconds, and hopefully in the next round you'll be able to answer them.
So that in 10 seconds. But I think in terms of violent offenders, I believe Chief Montour and Chief Davis have both spoken extensively about that, and they're better qualified than I am and experienced than I am to comment on that. I talk about what the interaction I have with residents on a weekly basis and what's happening in their lives, most of them, and what it is they're experiencing and what they're telling me what they think about the justice system.
Thank you, Mr. Moore. Ms. Dillon for 6 minutes.
Thanks to our witnesses for being here. I'm going to start with Mr. Spratt. You gave quite a horrific description of jail conditions, and this is in Canada. Can you talk to us a little bit more about what you mean by people coming out worse off when they are incarcerated?
Sure. I'm not a criminologist. I know you've heard from Dr. Myers and likely from some other criminologists who can provide the data that suggests that that is the case. But what we see in jails is a dehumanizing system that leaves people broken. Someone who is denied bail will lose their job, will lose their housing, will lose connections with family, is unable to maintain those connections because it's expensive to collect phone calls from jail. They're unable to set up treatment and counseling when they're released from jail because they don't have those primary supports. And when you combine that with an utter lack of rehabilitative services for people on remand, it means that people who are held in custody, and we've known this for decades, from the We May report, we know that we are risk adverse when it comes to releasing people. And what that means is if bail is made too hard to get, if it's made too onerous, and if we use isolated tragedies to craft general legislation that applies to everyone, that's not the way we should be doing it. We need to legislate generally and have that applied specifically, looking at the nature of the allegations, looking at the person's circumstances, looking at the supports available to them. Because when you get it wrong on bail, the community suffers. And if you're a conservative and you're interested in dollars and cents, and we're looking at paying $80,000 a year to have someone in provincial remand, that should be troubling. If you're someone that just cares about humanity, as I'm sure everyone does, it should be troubling that we treat people that way. And if you're just worried about what your constituents think and what the people in your community think, you should be concerned because someone coming out of jail after those conditions puts your community in danger.
Thank you for that. And I'd like to follow up with your comment about not making generalizations on the entire population because of some very tragic, specific cases. Could you tell us a little bit about the positive impacts of letting out somebody, an accused, rather than keeping them detained during the entire bail process?
Yeah, and I'll just go one step further. The problem about making sort of generalizations based on specific cases is we don't even seem to have people who care to get the primary facts right about those specific cases. The tragic death of Officer Pershala, reverse onus would fix this, except it was his bail review. It was already his onus, so reverse onus wouldn't fix that. So if you're really interested in fixing it, we need to look at some larger systemic issues. And when you have someone who's out on a well-supervised bail, that can be monitored by the police, that can be supervised by a bail program, that has the access to justice resources that allow check-ins and support. That is a perfect way to, while someone is presumed innocent, mind you, assist in their rehabilitation because it can be supervised, it can be monitored, and rest assured from everything that we've seen in court, our courts take serious violent offense seriously. When we look at prolific offenders and people with long records, that is taken very, very seriously. And so bail is the perfect time to make sure that people aren't set back. And it's, in fact, a time to help people take a step forward.
Can you please talk to us about racial bias? You have spoken about it during your opening statement, the impacts of that.
Yes, we've seen this in bail cases like Antic, but we've also seen it in cases from the Court of Appeal in Morris, from Nova Scotia Court of Appeal in Anderson. There is systemic issues with respect to over-criminalizing and over-incarcerating racialized individuals and especially Indigenous individuals. And when we look at firearms specifically, it's easy to come at it from a downtown urban setting. Although in many of those urban settings, we've actually seen some decrease in gun offenses over the last little while. But as I said, statistics are dangerous, and you have to be careful with small sample sizes. But when you look at Indigenous populations, I just got back from a circuit up in the Northwest Territories, where the use of firearms, the culture of firearms, the type of people who have firearms is very different than down south. And so if you have one-size-fits-all rules, it can lead to injustice for some people that don't and haven't traditionally fit in what we imagine the criminal justice system should be.
And my follow-up question to that is, have you seen, let's say, those who are Indigenous or of the Black community, what they are accused of is less severe, yet they are still denied bail comparatively to more violent crimes?
Yes, and I mean, our courts have been very clear at the bail stage and at the sentencing stage. If you are charged with a serious crime, just because you're racialized or Indigenous isn't a get-out-of-jail-free card. In fact, there's very harsh punishments. But what we do see is a systemic bias. If you are a rich white kid from the Bridle Path or from Rawcliffe, your parents can set up private treatment. They can put down a large amount of money. They can take a day off work to come and bail you out. If you are a poor kid with a working class family, you don't have those same advantages, and we see that trickle down into the disproportionate incarceration of a variety of groups.
Thank you so much.
Thank you, Ms. Dillon. We'll now go to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I, too, wish to thank the witnesses for being with us. This is an important topic. And I think we will never hear too many points of view. My question is for Ms. Bordelais. I heard your description, Ms. Bordelais, of the harrowing experiences of some in detention, and you're not the only one who's mentioned it. Mr. Spratt has as well, and other witnesses have brought this up as well. I'm aware that our prisons are not safe places and places to flourish for anyone. Obviously, they're not intended to be per se either, but I understand there's a lot of work to be done to make our prisons truly conducive to rehabilitation. This said, much of the population tells us that, yes, look, it's terrible, this levels of reoffending, recidivism. We need to ensure that people who are accused of carrying out serious crimes, firearm-related offenses, don't come back to the streets, weaponized, to commit crimes again. We're all aware of some of the cases. So there we have Canadians who are worried about that. And we also have, and my colleague Mr. Moore brought this up earlier, there are the premiers of the provinces who unanimously are asking the federal government to do something about this. I'd like to hear you on this matter, Ms. Bordelais. If we don't increase the number of people in pretrial custody and remand, how will we meet the request of the premiers and respond to public concern to make our society safer? How can we do that without being stricter with people who are charged with firearm-related offenses? Thank you very much for your question. I support, may I say, what Mr. Spratt said earlier, because the situation in Quebec resembles what is seen elsewhere in Canada, as he has described. To your question, I think that training counts and not enough emphasis is put on it. Unfortunately, there is a tendency to speak to specific cases without, unawareness of training to look at statistics in general. I don't want to say that these cases aren't relevant, but we tend to focus on situations where there's a high level of violence and think that people who commit serious crimes are reoffenders. That's not the case. Judges, of course, and Crown prosecutors are very aware of the people's concerns about safety. So someone who has a record of violence will be treated differently than someone else, much more attention is given to the question of whether they should be released or not. We haven't much time. I'm really sorry to interrupt you. But I would like to know whether you would tell the Prime Minister to, forget it. We're not going to increase anything. There's nothing we can do at the federal level to change the situation, or nothing we should do to change the situation. No, that's not what I would say. I would say, first, let's stick to reality and what we know. Second, let's make sure we do what can be done, because people who are, the brunt of these sorts of accusations have a background, have a lived experience that must be taken into consideration. If you're looking to prevent crime, first and foremost, I'm sorry, Ms. Mulder, I really don't wish to be impolite, but I've only got 6 minutes. Thank you so much. Mr. Davis, same question to you. What should we do as legislators in response to the Premier's concerns and the concerns of the people of Canada?
As I said previously, I'm here to speak to the concerns that that my community has, and I think to a subject that I don't think the committee has heard much about, and that is the constellation of nonviolent crime and what's happening with respect to nonviolent crimes. I think you've had lots of witnesses that have talked about violent crime, gun-related crime. I don't have much to add to that in terms of what you've already heard from our chief and the chief of Six Nations police force. So I'm talking about a subset to that, and my concern is, as a lawyer, people losing confidence in the administration of justice. And part of it is through the headlines they read in terms of violent crime, but it's...
Yes, but if I may, quickly. Ontario has gone over 7.6 million, has spent that much for a special team to ensure that people who are accused of serious crimes that are firearm related be denied bail. That's your government, Ontario. Is this a measure that should be applied, an action we should take at the federal level to ensure that all provinces use the same approach, the same type of intervention? Or is this just something we should leave to Ontario alone?
If it's successful and it is having an impact in reducing violent crime, obviously you would hope it would be used across the country.
Merci, Monsieur
You
Davis.
can't argue with success.
Thank you, Mr. Davis.
Oui, merci.
Thank you, Monsieur Fortin. Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. I want to turn to Madame Bordelais. You talked about quite disturbing conditions in pretrial detention in Quebec, and I wonder if you could maybe address the obvious. What impact do you think that those conditions in pretrial detention and the large number of people in pretrial detention has on public safety?
Well, something I was hoping to have time to tell you. And, Mr. Lametti said when he set up a committee, by the way, to address some of these issues, mentioned that when you're in such a situation, you will plead guilty to pretty much anything, even if you haven't committed the crime. And that's something I wish to emphasize. And this is what I find worst about all this, the fact that people who are racialized, Inuit people and women will tend, more than others, to plead guilty just to get out of the harrowing experience they're stuck in. And as a citizen, as an attorney, I think this is highly troubling.
To the system, what do you think would be the best ways to reduce the over-incarceration of marginalized and racialized people in the system? I mean, how can we get at this problem that seems to contradict the Supreme Court's decisions?
Well, I think that if we look specifically at the racialized Indigenous people and women, these aren't necessarily those who are committing the most violent crimes. I know that in the Black community, I know there's an issue with firearm-related offenses. I won't get into that in depth, but let's begin by looking at the statistics. In the statistics I gave you, was shown that those crimes that are reoffenses are often linked to breaches of conditions. So there's not necessarily a severe crime or a violent crime that's been committed. The person is, had a alcohol restriction and they've been found drinking, alcohol prohibition. So this is something that should be addressed. Often it's not actually reoffense, it's a breach of conditions. Because this is what leads to most of the remands.
Programs widely available to marginalized people in Quebec?
Je pourrais pas répondre nécessairement à cette question.
Well, I don't have a clear answer to that. What I can say is that someone who is homeless, who has poor, who isn't easily able to use or communicate with an attorney is more likely to breach conditions, to not go to court when they are asked to, or to one way or the other breach their conditions that will lead to their being put back in custody. So there's a kind of a revolving door. Those who are marginalized, who are uneducated, who are isolated, they'll wind up in custody.
I want to turn to Mr. Spratt and along the same line of questioning about the impacts of these conditions in the pretrial detention on public safety, and maybe you could say a bit more about what you've observed.
I mean, I think one of the most disheartening things that I've seen, and I think every criminal defense lawyer has seen, are individuals who are pleading guilty not because they're guilty or not because they're remorseful, but because they will do anything to get out of jail. I think I would, given what I know about those conditions. And it's that sort of perverse incentive that's been well studied in the context of minimum sentences that is most concerning, because now you not only have someone who has lost confidence in the justice system because of how they were treated, what they were forced to do, and the conditions that they were in, but you now have someone who, unfortunately, disproportionately we see as racialized and marginalized, now have a criminal record, which makes it all the more difficult to get a job, to reintegrate into society, to volunteer, to be, the pro-social person that we and they want to be. And so it's this cyclical and self-fulfilling prophecy that really needs to be stopped. And we need to do that through funding things like treatment, like bail supervision, and insisting that our municipal police forces and our other police forces allocate resources like that responsibly, so that if there is a bail breach and someone doesn't show up to court, that we're alerted before there's a tragedy.
And so Mayor Davis has raised this question of the nonviolent offenses and the repeat nonviolent offenses. So what you're actually saying to us is that the system we have now actually contributes to that repetition rather than helping to solve it?
It does. And perception is something, too, when we don't have grown-up conversations that actually deal with the facts and deal with the underlying issues, and we reach for quick solutions through the criminal code, the public does see things bleak and dangerous, when in fact we know from the statistics, especially when it comes to those minor crimes, that we have never been safer.
Okay, thank you.
Thank you, Mr. Garrison. We'll now go to our second round. We're just going to, in the interest of time, do them for 3 minutes, if that's okay. Mr. Van Popta for 3 minutes.
Thank you, Chair, and thank you to the witnesses for being here. Since we only have 3 minutes, I'm going to focus on Mayor Davis. So thank you for being here, sir, and for your earlier testimony. Now, coming out of the Brantford City Council, there were a couple of motions made recently. Perhaps you could expand on those. One was urging the federal government to strengthen bail system, and the other was to do with provincial initiatives. Perhaps you could expand on those.
Right. It was two-pronged. One was directed to the federal government, the Department of Justice, and in particular referenced some of the cases that I talked about earlier, and asked the federal government to consider changes to Section 515, similar to what I had spoken to earlier, and that is tightening up some of the rules in respect to sureties, and also giving greater consideration to the third ground. It wasn't focused solely on the federal government. It was also, there was a resolution directed to the provincial government asking for greater resources to be spent on the judicial system to reduce the delays that can create much of the prejudice and inequities that other commentators have mentioned. And so it was an encouragement to the provincial government to look at its policy that it has, that it gives to Crowns in respect to bail hearings, but more importantly, to spend more money on the system to improve it. So it went two ways.
Thank you for that. Now, the person who's been charged with murdering Constable Pershella was subject to strict surety supervision requirements, but he just didn't abide by them. We had Chief Montour here of the Six Nations Police Service, and they were responsible for supervision, but he told the committee they just did not have the resources. Could you comment on that?
Yes, I've talked to Chief Davis about that, and I didn't want to give the impression I'm not concerned about violent crime. I am. And I certainly support the position that Chief Davis advanced before the committee and the concerns that he has, and those that talk about the reverse onus for those kinds of crimes, I would support that. As I said, I thought my role here was to talk about something that I don't think has been talked about that much. And to me, it's another aspect to this that should be addressed.
Thank you, Mr. Van Popta. Ms. Briard for 3 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. And thank you again to our witnesses here at the second hour. My question is for Mr. Spratt. Thank you for your comments. Everything you've mentioned, we could have discussed for a good 6 minutes each single point, but I'd like to hear you, while Mr. Mayor has told us that there isn't a proper balance between public safety and accused persons' right to liberty. So what's your point of view on this?
Strike a very good balance, and that's not to say that the system is perfect. Striving for a perfect bail system has resulted in what we found in Ontario. I saw Mr. Nakvi here when he was Attorney General and launched a number of studies that when we're too risk adverse, when we strive for perfection, we end up detaining people inappropriately. And that can lead to, as I've described, some bad consequences. So it's not that the system will ever be perfect. People will breach well on release, but we have to do our best to try to mitigate that. And part of that is making sure that police allocate their resources properly to do compliance checks. Part of that is to make sure that we've got good bail supervision and other programs. And I can assure you that for serious offenses, courts balance. It's a secondary factor. The security and safety of the public. They look at an individual's record. They look at history of noncompliance. They look at a plan. Sureties are cross-examined. Hard questions are asked. And so this balancing is done. And if it is not done properly, then there's always the ability for the Crown to appeal that. And so we do have this balance that takes in all of those factors, looking at the specifics of the allegations and the specifics of the individual. And it's really when you try to strive for perfection and when you look at examples and you don't necessarily, in an intellectually honest way, look at if the solutions you're proposing would actually have affected that particular example that you look at. It's then we get into problems of really eroding the fundamental purposes of bail and how that interacts with the protections that we have under the Charter of Rights and Freedoms.
Merci beaucoup.
Thank you. This is truly interesting. And then following up on what you said earlier to the effect that pretrial custody increases recidivism, I'd like to hear more about that based on what you've just shared.
Yes, so it's well documented, not only in the context of bail, but in the context of sentencing as well. It's not strict bail that is going to stop someone from committing an offense, just as it's not a strict sentence or a long sentence that will deter someone from committing an offense. If we think that there's that level of precognition and planning, if someone has mental health or addiction issues, then we're deluding ourselves, and that's borne out in the evidence.
Thank you. Thank you, Ms. Briar. That will conclude our panel. So I want to thank you guys for attending. And I think that's our last bail meeting too, and we'll be working on it later. So thank you once again. The meeting is now adjourned.